Welcome to the Legal Soundbite for Q4 2023. In this edition, we have a risk theme around some recent developments. In August, the UK government published its latest National Risk Register. This is a wide-ranging document running to almost 200 pages and aimed at the broad range of risk and resilience practitioners. For the first time, the register is based on the government's own confidential risk assessment and uses two different timescales for assessing likelihood, within the next 2 years for malicious risks and within the next 5 for non-malicious. The register identifies 89 threats set out in the risk matrix on page 14. Of those with a potentially catastrophic impact, a further pandemic is the most likely, assessed at between 5 and 25% within the next 5 years. Other catastrophic events, albeit with lower likelihood, 1 to 5%, include larger scale chemical, biological, radiological and nuclear attacks, and failure of the national electricity transmission system. The register also identifies several other events which are less likely, but which would have a significant impact. Severe space weather, low temperatures and snow, an outbreak of an emerging infectious disease, conventional attacks on infrastructure, and what it terms a nuclear miscalculation not involving the UK. Overall, the register provides a detailed review of the risk landscape and a series of scenarios for organisations to consider in enhancing their resilience. Also in August, the SRA published its first annual assessment of continuing competence. This found that most firms are ensuring that their employees remain competent, but some firms are not. There's evidence that solicitors are not reflecting on their practice and identifying what needs to be addressed. The SRA analysed 42,000 reports referred to it from 2019 to 2023, citing one or more competence issues. Over half of the reports, 52%, concerned ethics, professionalism and judgment. 30% involved working with other people, and 27% technical legal practice, followed by managing themselves and their work in 26% of cases. Some of these failures, poor judgment and technical legal practice, strained relationships with colleagues, lack of personal organisation, feature in some of the claims we see. Slips and lapses in managing the retainer properly, drafting error and effective advice. Given that, the competence regime and ensuring compliance with it could be seen as part of a firm's overall risk management effort. In terms of work areas, residential conveyancing and probate generated more reports than any others. Immigration and asylum firms also featured. As a result, over the next 12 months, the SRA will be carrying out thematic inspections of a sample of residential conveyancing and/or probate firms, as well as those offering immigration and asylum. So a heads up for firms in those areas. And staying with the SRA and compliance, an apparent change of tone in its approach to regulation and enforcement. At its annual Culp and Coffer conference in October, the SRA indicated a tougher stance for non-compliance, heavier regulatory fines on an automatic basis, and in the near future, power to impose unlimited fines for AML breaches. To focus minds on self-regulation, there is the potential for fines across the management team. In terms of risk and the threat of fines across the partnership, this probably means much more focus on systems and processes to ensure compliance, especially around AML, something that the risk team here at Travellers will be tracking. So some risk issues to ponder as we head into 2024.